it was destroyed. It got damaged and it was destroyed. But the parties, when they agreed to buy and sell, didn't know that it was destroyed. They thought it was still in existence. So that was our common mistake. The effect of this is that the contract is set aside because the subject matter of the contract doesn't exist anymore. Similarly, though slightly quirkier, in Galloway versus Galloway, a husband and wife entered into a separation agreement on the rather understandable assumption that they thought they had been properly married. When they then found out that the marriage was a nullity for a variety of reasons, the separation agreement was then deemed to be void for common mistake. So the mistake they made is they both thought they were married, and as a result of that they entered into the separation agreement, but as they weren't in fact married, the separation agreement became unnecessary. It then became unenforceable and was void. So in the Sale of Goods, Section 7 of the Sale of Goods Act 1893 provides that mistakes to the existence of goods for sale under a contract renders the contract void. Now, again, just to recap on void versus voidable, because this becomes very important later on in this topic. A contract that is void is one that has never existed, therefore there are no rights or obligations under that contract. A contract that is voidable is a valid existing contract until one party makes deliberate steps to set it aside. So there is a contract, rights and obligations do accrue under the contract, and the contract only comes to an end when one party seeks to set it aside. Okay, so the question is, if a contract is voidable, so that's the second category of contract, how does that work? Do you get all your money back or your goods back? The answer to that is that it works very much in a case-by-case basis. So the judges would look at how best to do justice in that particular case, and if it was possible to set both parties back right at the beginning, they would do so. But the real significance of a voidable contract in the issue of mistake is third-party rights. So if you have third parties who buy the subject, the item on at a later stage, then if the contract is void, I tell you what, we're going to get into that in a bit of detail in the end of the class, so I won't confuse matters by rushing ahead now. But the answer to that question, and it's a good question, is the judges will look at it on a case-by-case basis and try to do justice to the parties. In some cases, they will allow the goods to be transferred back. In other cases, the goods might be used. It might be for a contract for services. So they will try to do justice depending on the facts of the case. One very important issue in common mistake, what we're looking at in common mistake is if the court finds that there has been a common mistake, the contract is void, and it's never come into existence, so the parties just effectively walk away in as much extent as they can. Or rather, if there's been an exchange of goods or exchange of money, then that transfer has to go back. One way that this concept of common mistake can be stepped around is in the allocation of risk in either in the contract itself or in the pre-contract discussions. So, for example, we'll take the case of Couturier versus Hasty, which was the one where there was a cargo of corn that was on the way to London, and both parties entered into the contract for the purchase of the corn, and it turned out that the corn didn't exist, so the contract was set aside. If one party had said to the other, "Are you sure the corn is going to get to London okay?" and the other party said, "I'm positive it'll get here," the party who said, "I'm positive it'll get here," has now accepted the risk that if the corn doesn't get there, he'll be responsible. So it's an allocation of risk. When one party, either expressly or by implication, allocates the risk to himself, then he's responsible for the problem caused or the damage caused. The allocation of risk can be both express or it can be implied. So there can be a distinct statement in a contract if there is a problem with the subject matter of the contract, the problem is with the seller. Or the courts can look at the discussions and the contractual negotiations and the correspondence between the parties, and as a result of that correspondence they can decide to allocate the risk in a particular way. The leading case in the area is McRae versus Commonwealth Disposals Commission. It's an Australian case, and the case revolved around the existence or non-existence of a wreck. The Commonwealth Disposals Commission told Mr. McRae that there was a wreck on a particular reef at particular coordinates. McRae then entered into a contract for the salvage of that wreck, but when he went to that particular location at those particular coordinates, he found that there was no wreck there. So again, it's a classic example of a common mistake whereby both parties thought that the wreck was there, the wreck turned out not to be there, so you have your common mistake. But the courts looked at the correspondence and the interaction between the parties and concluded that the Commonwealth Disposals Commission had accepted the risk, and they had done so because they'd been reckless as to whether or not the wreck was there or not. They said that the defendant had, by implication, guaranteed the existence of the wreck, and in so doing, the court placed great emphasis on whose fault it was. So they're introducing this idea that if you should have known or had more knowledge about the existence of the subject matter and you were negligent or just incompetent and the fault was yours, then the courts will imply that you've assumed the risk, that if it's not there, you'll be responsible for it. Okay, so that's the clearer of the two and the easier of the two, the whether or not the subject matter actually exists. More complicated is this question of mistakes as to fundamental assumptions behind the contract. So if the mistake that both parties are operating under the same mistake, if the mistake makes the performance of the contract fundamentally and radically different, then it's possible that even though the subject matter exists, that this mistake as to the underlying assumption will mean that the contract, you can argue that the contract is unenforceable and void. The leading case in the area is Bell versus Lever Brothers. Bell versus Lever Brothers is a case that involved the termination of an employee's contract. So Mr. Bell was, I think he was a managing director of he was chairman of one of the subsidiaries of Lever Brothers. And when his contract got terminated, he was paid a golden handshake, which was a very generous redundancy package. At the time that he was paid that generous redundancy package, both Bell and Lever Brothers thought that he was contractually entitled to it. So they both thought that there was an element, a clause in his contract that entitled him to a golden handshake. It then transpired, after the agreement was reached to pay him a golden handshake, that there was no such clause and there was no obligation on Lever Brothers to pay him this lump sum. As a result, Lever Brothers sought to set the contract aside on the basis of common mistake, saying that although there wasn't a mistake as to the subject matter of the contract, there was a fundamental mistake, and a mistake underlying a fundamental assumption. The fundamental assumption is, in this particular instance, is that they had an obligation to pay the money. When they found out that they had no such obligation, they then sought to set that particular contract aside. The courts found for Bell, and they found that the mistake wasn't of such fundamental importance that it should be allowed, that Lever Brothers should be allowed to set the contract aside.